Thank you for everyone joining today, and welcome to the Paces Ferry Wealth Advisors webinar on the Paycheck Protection Act and the Family's First Coronavirus Relief Act. We hope everyone is safe and healthy, and we're glad you're able to carve out a few minutes for our webinar today. A little bit of information about Paces Ferry Wealth Advisors. We provide wealth and investment management for high net worth individuals with a focus on in-depth retirement and income planning. And typically, the folks that find the most value in working with us have been asking themselves the question, am I doing everything possible to set myself up for the future? My name is Zach Morris, and I'll be your host for today's call. And I'm a wealth advisor and co-founder of Paces Ferry Wealth Advisors. With the new CARES Act being passed just recently, we thought it would be important to discuss these two widely discussed topics that present both opportunities, but also some potential blind spots that employers need to be on the lookout for and prepare themselves. Paces Ferry Wealth Advisors is a registered investment advisor with the U.S. Securities and Exchange Commission. And please keep in mind that this webinar is for informational purposes only. Paces Ferry Wealth Advisors does not provide tax or legal advice. And please contact your trusted advisors before implementing any strategies discussed in today's call. Our first guest speaker is Betsy Bulat-Turner, who is a partner with Martinson, Hasbrook & Simon. Betsy defends labor and employment litigation from small claims to class actions and counsels management and executives on related business compliance matters. Betsy takes an efficient approach towards simplifying and organizing complex disputes and compliance issues. And Betsy, we look forward to hearing what you have to say today. I'll turn it over to you.
Great. Thank you so much, Zach. Thanks for the intro and for organizing this great webinar, which I think will be helpful for a lot of your clients and our clients and any small business owner or even some larger business owners who want to take advantage of certain portions of the two acts that we'll be addressing today. My portion will be addressing, as you mentioned, the Family's First Coronavirus Response Act. And I'll tell you a little bit about what that means. We'll be focusing on two provisions of that act, the paid sick leave provision and also the expanded FMLA leave. I'll be going through this extremely quickly. There are 800 pages of temporary regulations addressing this law alone. And I know everyone on the webinar wants to get to the free money section of this webinar, which is not me. So I'll try and move these along. That said, if you do have any questions or any concerns, anything I can clarify while I'm speaking, please do use the chat function on the webinar to pass those along. Zach will be monitoring all of the questions he gets through that chat function and passing those along as appropriate to me during the webinar. So please do ask questions. This is absolutely for your benefit. And Zach, I'm trying to go through to my PowerPoint, and I'm clicking. Oh, perfect. There we go. So as I mentioned, there's two parts of what I'll call the FFCRA that we're talking about today. The first is the paid sick leave portion of the FFCRA, and that essentially, in a broad sense, grants up to 2 weeks or 80 hours of paid sick leave to employees of companies with fewer than 500 employees. And that paid sick leave is given to employees for 6 reasons. So if you're subject to a quarantine order issued by a federal, state, or local government, if you've been advised by a doctor to quarantine, if you are experiencing any symptoms of COVID-19, if you're caring for someone quarantined, if you have childcare responsibilities, if your son or daughter, if their school is closed or if their daycare is closed. And then finally, the 6th reason, any, quote, substantially similar, unquote, conditions. So it's quite a broad act, and it's quite generous in terms of the 2 weeks of paid sick leave. The second element of the FFCRA we'll touch on today is the expanded FMLA leave protections. Most of us are familiar with the FMLA leave, FMLA and law and what that provides for your employees, and that is applicable to typically applicable to employers only with 50 or more employees in a 75-mile radius. Well, the new FFCRA upends all of that. At this point, it is expanded even to smaller employers with fewer than 50 employees, with a few exceptions that we'll talk about today. So first topic, who is covered by the FFCRA? I think somewhat counterintuitively, the FFCRA applies only to employers with fewer than 500 employees. A lot of my clients are saying, this isn't fair. It should be employers on the opposite end of the spectrum, those employers who are large and have the money to float obligations like these during this time period. Well, I think that the Senate's reasoning was just that they feel some of the larger employers are already providing some of these benefits, and they felt that these protections needed to be focused on some of the smaller businesses for better or for worse. For many of my clients, probably for worse. In counting toward that 500 employee threshold, you include all full-time employees, all part-time employees, all temporary employees, and also any employees on leave or any vacation. So it's an all-encompassing employee count that you get to use. Some examples of employees you would not count toward that 500 employee threshold would be 1099 independent contractors, any employees who work outside of the U.S. if you have an international business, and then any employees of separate affiliates. So even if you have a parent organization or a subsidiary or affiliate, if that other organization could not be said to be the joint employer of your employees, you would not aggregate the employees of those two companies together for purposes of determining your 500, or whether you fall above or below the 500 employee threshold. So I've gotten a lot of questions about the 50 employee or the so-called 50 employee exemption written into the act. A lot of my clients have been calling up and saying, hey, we have fewer than 50 employees, are we exempt? Well, the question is likely not. And even if you are, the exemption that is allowed is so narrow, you don't avoid many of the obligations that the FFCRA requires of employers. So to start, just so you all understand, I will talk about what this exemption means and how you meet it. But what it only does, it takes away the paid sick leave obligations and expanded FMLA only for childcare. So that was just one of those 6 reasons that we talked about at the beginning that you can use to qualify for paid sick leave or expanded FMLA leave. The only thing the exemption does is potentially relieve employers from the obligation to provide paid sick leave and expanded FMLA when their employee needs to care for their children due to school or daycare closures. All of those other reasons we talked about, self-quarantining because of an order or doctor's advice, experiencing symptoms of COVID-19 or caring for someone who does have those symptoms, you would not be exempt from providing paid sick leave for those reasons under any circumstance. So the exemption, if you're under 50 employees, is not automatic. It's something that you can meet if you attest and meet one of the three scenarios or factors you have to meet to get that exemptions. Big picture, you have to show that providing paid sick leave or expanded FMLA for childcare would cause or would jeopardize the viability of your business. And you can show how your business may be jeopardized in 3 different ways. First, if providing this paid childcare leave would cause expenses and financial obligations that exceeded your revenues and therefore cause your business to become unprofitable. That's the first thing you would need to show to meet the exemption. Second one you could show is that there is a substantial risk of having operational difficulties because of your specialized skills of your employees if you provided this leave to those of your employees who have these specialized skills. So an example of something like that would be you have employees, only a handful of employees that can do a particular function at your business. If all of those employees took leave, then you would be unable to function. So I work for a law firm. I have a law firm, and we have an office manager, and she's the only person that knows how to use our billing software. So the only person who can really ensure that we get paid is our office manager. It'd be really difficult for anyone else to get in there and do it. Well, if she took leave for childcare purposes, arguably we would not be unable to continue functioning. So because of her specialized skills, arguably we need to retain her. She would not be able to take the childcare leave authorized by the Act. Finally, you could show that simply by providing all of this leave, you'd have insufficient labor to perform the necessary work at your business. That's another way you can meet the exemption. The way you show these exemptions is simply by documenting which of those 3 reasons you believe apply to your business and having an officer of your company certify that those conditions do in fact apply. I've had a lot of questions from my clients about, do we have to submit that certification to the DOL or to any other particular entity? And the answer is no. You would just want to document those, retain it for your files, make sure that, an authorized representative of your business does a good job describing the reasons that apply to you and certifying that they apply to your business. So the first part of the FFCRA that I mentioned, if it applies to you, is paid sick leave. And employees can receive up to 80 hours of paid sick leave over the course of the 2-week period for any of those 6 reasons that I talked about. And I won't go over them again, but you can see those 6 reasons there on the screen. So for any of those reasons, with the exception of childcare, pay is capped at $511 per day or $5,110 in the aggregate. And that's the most that they can get. So they either get their regular pay, regular salary, or at most $511 per day or $5,110 over that course of that 2-week period for the paid sick leave. For those part-time employees who may not be working a full-time schedule, they typically don't get paid, whether they don't get paid for full 80 hours over the course of 2 weeks. Those part-time employees would be paid for their average amount of hours worked over the prior 6-month period of their employment. So it's essentially diminished pro rata to align with the amount of time that they typically work. Second part of it is the expanded FMLA portion of the Act. Most of the typical FMLA rules that you are used to complying with will apply here. What the FFCRA does is really just add another layer to the FMLA and allow use of FMLA for a new reason. And that is to care for a minor child because the child's school or childcare provider is closed due to COVID-19. In those cases, an employee could receive up to 12 weeks of leave, and 10 weeks of that leave, the 12 weeks of leave would be paid. The pay for this type of leave is not full pay. It's payment at 2/3 up to a maximum of $200 per day or $10,000 in the aggregate over the course of that 12-week period. Here, generally, to be subject or to be eligible for FMLA, you have to have worked for a company for at least a year and have worked about 1,250 hours over the course of that year. Well, here, the FFCRA advises the Act to state that employees who have worked just for 30 days for the company are now eligible. Other than that, many of the normal FMLA rules will apply, including certification rules. So you can ask your employees for certification to confirm that they are truly entitled to be taking the leave that they've requested. So some of the common issues we've been dealing with, I wanted to just talk about these since we've gotten so many questions. I've gotten a lot of questions about how the 2 acts work together. Well, you can get paid sick leave and you can get the expanded FMLA. They're not mutually exclusive and they really do work together. And you can see that because you can get paid leave for childcare issues for 2 weeks under the paid sick leave aspect of the bill. After that 2-week period, you can then get paid under the expanded FMLA period. The first 2 weeks is still FMLA. It still counts against the employee's 12-week FMLA entitlement. But after that 2-week period, you only get paid under the FMLA. The expanded FMLA law states that the first 2 weeks are not paid. And that's because the paid sick leave factors in to allow payment during that first 2-week period. Second question I've been getting a lot of is, what documentation can we ask from our employees to support the need to take paid sick leave for any of those 6 enumerated purposes? So you can ask for doctor's notes if it is a medical issue. I will tell you the CDC has recommended that employers not do that because of the burden on the healthcare system, but that aside, you can still do it. And I do advise that you get some type of documentation because you'll need it when you claim tax credits for paying out the sick leave at the end of the year. So all of the paid sick leave or expanded FMLA paid time that is going out under these 2 portions of the Act, that can be claimed as a tax credit at the end of the year. And in theory, you'll get that all back from a tax perspective. But as usual, whenever you're claiming a tax credit, you have to show some documentation. And you can do that both with the medical notes or the doctor's notes you can get, or simply a statement from an employee that they need to go, that they need to take leave for one of the qualifying purposes, and they just sign off on that. Whenever you get a request for this type of leave, I also just recommend you document it in general with the name of the employee, the dates of leave they requested, the purpose of the leave, and then their certification of why they need it. And that will help you keep it all in line. Next question, conducting layoffs during leave. Gotten a lot of questions about if an employee takes paid sick leave, they're out on paid sick leave, or they're out on FMLA or expanded FMLA leave, can we furlough them during that time period? The answer is yes. If you would have furloughed them, even if they had not taken the leave or had not taken the paid sick time, you can move forward and make whatever business decision you would have made if they had continued working during that time period. Obviously, you want to be able to show that you have good, legitimate, justifiable business reasons for making that decision as you would in any other circumstance. But the Paid Sick Leave Act and the Expanded FMLA Act don't on their own bar you from making those decisions during leave. Prior exhaustion of FMLA leave, I've had folks ask, well, Betty Smith just got back from maternity leave and she took her entire 12 weeks. Are you saying that we have to give her another 12 weeks of time off to care for her children? The answer is no. The law does not change the fact that you get a maximum of 12 weeks of FMLA in any calendar year. So if someone is taking their expanded FMLA under Act, they can't go on and take another 12 weeks later on in the year. Conversely, if they've already exhausted their FMLA leave, they don't get a new 12-week period. And finally, we did get in one question before the webinar today about whether in jurisdictions where there are state or local laws that require a certain amount of paid sick leave, whether this paid sick leave is on top of that or whether it could be used contemporaneously. And the answer is clearly, the DOL has made this clear, that this paid sick leave under the FFCRA is on top of whatever other laws apply to provide sick leave or employer policies. So if you already have a policy that says you give 2 weeks of paid sick time, the FFCRA paid sick leave will be 2 weeks on top of that. Same with any state or local law requirements that provide sick leave. It's just giving employees another option on top of everything that they already have. I do see I've gotten a few questions as I was going along. One question, some government programs, temps are not counted as part of the total. Why this one? Good question, Larry. I don't necessarily know the answer to that, but I think it's a great point that this is not consistent with some of the other federal laws that we deal with. So in terms of meeting that 500 employee threshold, temps are included. I honestly don't know why. I'll ask my state senator next time I see him. From Lynn, for employers under 50, do we need to provide any FMLA at all, since we did not need to prior to this legislation? So Lynn, if you're under 50 employees, typically you're not subject to the FMLA. Now you do need to provide FMLA, but only for the reason articulated in the act. So, and that's only for childcare issues due to school or daycare closures. So this doesn't mean you're automatically and all of a sudden subject to the FMLA for every reason. It's just for that very limited and narrow kind of school closure issue. Oh, someone asked about the slides. Yes, I'll make sure that we can pass these on to all the attendees to have.
And Betsy, we had one other question.
Yeah.
Is the 80-hour paid sick leave in addition to their normal sick leave benefit?
Yes, so what I think that's asking is, if you already have a sick leave policy, would this 80 hours be on top of that? The answer is a clear yes. Yes, it is.
Okay. All right, great. Well, thank you, Betsy, for the very informative presentation on the Families First Corona Relief Act. Our next guest speaker is Corey Thrasher. She is a partner at the Atlanta, Georgia office with Starfield and Smith. She specializes in government guaranteed lending, commercial real estate, and banking. Corey represents both lenders and SBA lenders, as well as business owners who are buying, selling, or forming a business by helping them negotiate commercial real estate leases and helping them obtain financing. Corey, I'll go ahead and turn it over to you, and we all look forward to hearing what you have to say.
Thank you, Zach, and thank you, Betsy, for your presentation as well. I am just trying to click through to the next slide. Let's see. All right, today we're going to talk about the Paycheck Protection Program, which is a part of the CARES Act that was signed into law. And I think that the regulations and the interim final rules started coming down like last Thursday and Friday, which, while it was only a few business days ago, is like 84 years and 14 years. So I'm going to do my best to summarize sort of where we are today, because a lot of things have been changing. Let's see. All right, first of all, who can apply under the Paycheck Protection Program? So this program is basically an expansion of the existing Small Business Administration 7A program. And then the intention under all of this is to assist businesses with covering payroll costs, plus some other business expenses such as your mortgage interest on your commercial building, lease payments, utilities, and interest on certain pre-existing debt. There's a lot of questions around who can apply, who's eligible for these. So the basic rule is that a business must have no more than 500 employees. There are a variety of other standards that may apply, including SBA's alternative size standard, what's considered small under the business primary industry. And this is also expanded to include sole proprietors, independent contractors, and self-employed individuals. This is important because I've gotten this question a lot, but basically if you're a small business owner and, assuming you meet all of the other definitions, if you pay, a 1099 independent contractor on a 1099 MESC form, you can't count that in your calculation of your payroll costs, okay? Because generally they're not going to have any other payroll costs such as healthcare or anything like that. So, and the sort of flip side to that is that if you are a sole proprietor or the independent contractor or the self-employed individual, you can yourself apply for the PPP program based on your net income for the prior year. So that's an important distinction to make right off the bat. We also want to keep in mind that, certain businesses are still ineligible, such as, if you're a household employer. You cannot use this for your nannies and housekeepers. Banks, financial businesses primarily engaged in lending, passive businesses such as real estate holding companies, developers, landlords that do not actively occupy their property or their assets, businesses engaged in speculative activities like casinos, gambling, and life insurance companies, but not necessarily life insurance agents. Franchisees can still qualify for this program so long as they're listed on the SBA franchise directory, which is pretty readily available online. I've gotten a lot of questions from private equity companies and firms that are involved in finance and possibly could be considered involved in lending. That is a very complex analysis that gets into the SBA rules on affiliation, and I would strongly recommend that if you are asking those questions, you go to your attorney or an attorney who can specialize in the area of analyzing the affiliation issues, because it basically boils down to ownership and control in other, portfolio companies. And it can get very complicated very fast. So that's not something that you want to rely on whatever lender you're going to do. And in fact, most of them probably won't do it. So it's something that you want to sort out in advance, hopefully as quickly, as you're able to. This gets us into how much is available. Well, the program's been expanded to $349 billion that are available. I believe as of yesterday, the word was that $36 billion had already been approved under E-Tran, which is the SBA's portal that the lenders submit your application to. So as you can tell, and as you might imagine, there's like 30 million small businesses in the US. So it seems like a lot of money, and it is a lot of money, but it's going to be used up fairly quickly. Just getting into the details, the loan amount itself is going to be up to 2.5 times your average monthly payroll costs from the prior year, or for seasonal employers for the specific time window when you're generally busier, which is sort of the February or March window to June, up to a cap of $10 million. And also keep in mind that for highly compensated employees, your payroll costs are capped at $100,000. So if you have an employee that makes $90,000 or $95,000, and for some reason with benefits, including group healthcare coverage and other things, they make over 100, everybody's limited to 100 in your payroll calculations. And getting into the actual payroll calculation itself, the SBA has issued an interim final rule. It may be a final rule at this point with regard to the calculations. And it has some examples, but basically, you're not just calculating like your last month of payroll. You need to use 12 months if possible if you were in existence last year. So that's going to cover if you are an owner of a small business and you don't draw a salary, but you might take a distribution quarterly or at the end of the year or occasionally, you can factor that into your 12-month average. So you want to look very carefully at, your payroll provider, your records, because you are going to need to submit those to your lender at some point, either with your application or as part of the loan package and the documentation provided at that time. For sole proprietors and independent contractors, you're going to look at your wages and your net earnings for self-employment during that time period as well. I should point out that I don't believe that sole proprietors and independent contractors can start applying under the program until this Friday. So while the program began last Friday, the 3rd, that was generally for small businesses and small business owners, independent contractors and sole proprietors have to wait until this Friday to start applying. What are your allowable uses? You can use these for payroll costs, group healthcare coverage, salaries, commissions, interest on mortgage obligations, rent, utilities, and interest on other debts incurred prior to February 15, 2020. The rule actually goes a little bit further into this guidance and states that, similar compensation to salaries and wages can be utilized, which brings in the owner draw and allows you as an owner to, include yourself in the payroll, is all I'm trying to say. One of the features of this program that differentiates it from the SBA 7A program is that no guarantee is required and no collateral is required. And these are both, you know, really good benefits, and in that it will expedite everything, but also it's, you know, it's really designed to be the easiest way to get money to small businesses to try to retain workers on a going forward basis. The terms, initially it was going to be up, I believe, to 4%. That's been, basically the Treasury has said that they want this at 1% fixed. Payments are deferred fully for 6 months with that 1% interest accruing over the deferment period. Maturity date is 2 years from the date of the loan. And there won't be any fees paid by you, or at least not out of the loan proceeds, with regard to borrower, lender, or prepayment fees. There's no prepayment penalty. That is also a feature that sets it apart from the typical 7A program. The biggest component by far is the eligibility for forgiveness of a portion of the loan proceeds. So if you take out one of these loans, any amount spent in the next 8 weeks after you take out the loan will be forgiven if you use the proceeds for covered payroll costs. And of course, that's still subject to that $100,000 cap on comp. This also includes interest on your covered mortgage obligations and your covered rent and utility payments. So again, the goal of Congress is to, and of Treasury and SBA, is to use this to help small businesses get through the uncertain period of sort of the next 2 to 2.5 months. There's a lot of questions over, you know, what about my head count? What if I already laid off employees? What if I lay off employees during the 2 months? You do want to keep in mind that there are some reductions if you have laid off or you do lay off employees, because these funds need to be used for payroll costs. So if you can't use them for payroll costs, either because you already laid people off or you are going to lay people off in the next 8 weeks, you need to consider sort of why you're taking the money out and the forgiveness aspect. Treasury guidance indicates that at least 75% of the forgiven amount must have been used for payroll. Therefore, you know, if you take out the money and you're trying to use it, you know, solely to make your rent payments, that's probably not going to cut it in terms of forgiveness. Only about 25% can be used for sort of the non-payroll costs. How I'm going to apply this slide is a little bit outdated because it's been a couple of days. You want to go to generally your bank or banks. SBA 7A lenders that made 7A loans before this and are approved have a leg up because they've already got the systems in place. But under the program, all lenders are authorized to make these loans should they choose to. Some lenders did begin to accept applications on April 3rd, and obviously some have been approved since then. The final borrower application is now available online. Lenders are allowed to use their own borrower form. It is not very long, and it's relatively easy to fill out if you're kind of, you know, if you're not in a complex situation like a private equity company. As far as documentation, each lender may be different in what they require you to show to them, but basically anything showing your number of employees as of February 15th, all payroll forms for 2019, and of course evidence of your rent, your utilities, and any interest on existing obligations, and then your company formation documents and your EIN. These are all, if they're not at hand, talk to your accountant. Bank records will also suffice if you're a very small business and you don't use a payroll company or you're a sole proprietor. As far as the affiliation rules, you do need to disclose any 20% or more owner of the business. This gets into affiliates who are 50% or more owners of one or more companies, and what kind of control they exert over the companies. This can include common management, common interests, and other provisions that might be in the operating agreement or the bylaws of the company. And again, that gets a little more complicated than the topic of this webinar. And Zach, I'm going to try to flip it back to.
Yeah, and Corey, we had a couple of questions come through. Let me go ahead and put that last slide back up. There we go. One of the questions that we had come through was the use of proceeds. What is the use period? Does it have to all be used within the next 8 weeks, or does the company have the remainder of the year to use those proceeds?
Sure. No, that's a good question. But because of the way it's been calculated, like it's basically covering 2.5 months of payroll costs, hence sort of the eight week window. As a borrower, you're allowed to apply for forgiveness. I think after week 7 is up. So, and at that time, you're going to have to submit evidence that you did in fact use the proceeds, you know, with regard to forgivable indebtedness, such as the payroll costs. Any amount after the forgiveness period, which is 8 weeks after the loan has been taken out, any amount left over will be converted into the actual loan, which will then accrue interest at 1% and have that maturity of 2 years. So if for some reason you're unable to use the bulk of it on payroll costs, there is going to be some amount left over, and it doesn't have a maturity for 2 years. You can prepay at any time without a penalty as well.
Okay. And what about companies that have already furloughed workers? Can they use the proceeds to pay those workers, I guess, to make them whole for the weeks that they've already been furloughed?
Can you use the proceeds to pay them if you've already furloughed them? I mean, the requirement is that it be used to cover payroll costs. So I think a portion of that answer might hinge on whether, you know, have they already signed up for unemployment insurance? Because like you can't use it to cover your unemployment insurance costs for them. And similarly, if they're not actually on the payroll, I don't know what kind of retroactive provisions might be in place. And as a reminder, you know, the forgivable portion is dependent on how many full-time equivalent employees you have during the covered period. So, in the covered period of the loan, the first 8 weeks of the loan, compared to your base period, which would either be last year or in certain circumstances, a seasonal period, or the first 2 months of this year if you weren't in existence last year. I hope that answers the question. I know it gets kind of complex. But I mean, you know, the bottom line is, as an employer, you can make the decision, and it's going to require sort of business decision, you know, and math to determine if it makes more sense for you to rehire the employees or rehire a certain number of them. But you've got to look at, you know, what you've done in the past as well, because those records are what your lender is relying on for your eligibility.
Okay. Well, we don't have any, we just got another, this is a question for.
Oh, and I see a couple here at the end. And John, I see your question. He's asking to elaborate on the $100,000 cap on total comp. So, I mean, you want to look at an average of 12 months history. You don't want to just look at, you know, a couple of weeks or a couple of months. So if you've got like commission, salespeople on commission, then you're going to need to look at sort of the average, your average payroll, even including them, for the prior year. And so long as you can support that analysis, then, you know, then that's your analysis. Your lender isn't going to necessarily go behind you and double check that. The SBA is not necessarily going to go behind you and double check that. But as long as you've got like a reasonable basis for making those calculations, then that's going to support your loan amount. You know, whether or not you pay those people in the same manner, you know, may be different. It's got to still be that average cost, but it should allow you to retain them. Again, it's only sort of a 2.5 month period. This doesn't get you through the end of the year. Someone had asked before the meeting whether or not, given the limited funds available, the $349 billion cap, whether there might be more funds available at a certain point. And my understanding is, just based on, you know, what I've heard, and also a couple of things that have been in the news lately, is that yes, the government is considering expanding this or redoing it again to make more money available, because it is anticipated that you know, at the current rate of loan applications, they're probably going to be through this by mid-April. So, you know, but there are funds there now, so get your applications in as soon as you can, you know, so that you're a part of the process. And I also,
we have one question about a summer camp business only has payroll during July and August. That's beyond the next 8 weeks. So would the loan not be forgiven in that situation?
so it's not 8 weeks from now. It's 8 weeks from the time the loan application is received. I'm sorry, from the time the loan is made. So if you apply, okay, you know, if you apply in May or June 1st, then you can look beyond that. I mean, I would have questions about whether or not, I don't know if that business would in the normal time qualify as a seasonal business. I would imagine that it does. So you'd have to look at sort of some of the nuances in the rules governing seasonal businesses. But there may be some room there, and the law does factor or try to account for seasonal businesses like that.
Okay. In regards to the 100,000 cap, I know we had a question come through during registration. That $100,000 cap can also be applied to owners, depending on whatever their salary is. They can, if it's over 100,000, they can include up to 100,000 for their salary as well, in making that 2.5 times calculation. Is that correct?
Well, again, generally yes, assuming you can support that with your documentation, hopefully from last year. So if you as an owner, you know, a lot of owners don't take a, you know, a monthly or a biweekly salary at all. They may take it quarterly, or they may take money when they can. But hopefully, if you as an owner withdrew money as compensation from the company in the prior 12 months or whatever time period you're looking at, then that would support you paying yourself whatever 2.5 times of the monthly average of that is. You know, so if you waited until the end of the year and then you took out $100,000 for your own comp, you know, you're entitled, if you can support that, to take 2.5 times that, divide by 12, take 2.5 times that number to get your portion of your comp.
Okay. And we have one more question coming through. Once I receive the PPP funds, do I have to have my employees formally in their unemployment with the state? And then a follow-up question I would have is that something that would fall on the employer, or would that really be the up to the employee to make that move, to make that change?
Well, and you know, with the full disclaimer that I do not know anything about unemployment insurance guidelines and regulations, but I'm assuming that if you are employed, you have to make certain certifications every week that you're employed, you know, in order to collect unemployment insurance that you're not employed. So, you know, basically, again, the idea is that if you, you know, are taking this loan, the idea, the intention of Congress is to hire or retain or rehire employees. Then you know, the goal is that you use those funds, those loan funds, towards your payroll costs. So if you go out and you do need to rehire employees because you had furloughed them or laid them off or whatever you want to call it, then those employees would need to take whatever steps they see fit to come to work for you again, just under any normal situation if they were to be rehired in any context.
Okay. Okay, great. Well, Corey, we appreciate all the great information, and Betsy as well. We don't seem to have any new questions coming through, so, and I know we're running over a little bit on time, but I appreciate everybody's patience, and I hope this was a very helpful webinar for you. We've got all of our contact information up here. Please feel free to reach out to any one of us with any additional questions. And that will conclude today's webinar. Thank you very much for your time.
Thank you, everybody. Thank you, Zach.
Thank you.